The World Intellectual Property Organization is a specialized agency of the United Nations established in 1967 and headquartered in Geneva, Switzerland. It promotes the protection of intellectual property worldwide and fosters cooperation among member nations. WIPO administers over 26 international treaties such as the Berne Convention, Paris Convention, and Patent Cooperation Treaty. It helps streamline international registration of patents, trademarks, and designs. India became a member of WIPO in 1975 and actively participates in its policy making and training programs. The Indian Patent Office also uses World Intellectual Property Organization systems like the PCT and Madrid Protocol for global applications. WIPO plays a vital role in harmonizing IP laws and promoting innovation in developing countries like India through technical support and legal capacity building. Paris Convention, 1883. The Paris Convention for the Protection of Industrial Property, signed in 1883, is one of the earliest international IP treaties administered by World Intellectual Property Organization. It protects patents, trademarks, industrial designs, utility models, and trade names. Its key principles include national treatment, that is, equal protection for foreigners, as in same treatment like the domestic innovators, right of priority 12 months for patents and 6 months for trademarks or designs, and independence of patents. Each country's patent stands alone. India joined the Paris Convention in 1998, bringing its laws in line with global standards. For example, an Indian inventor who files a patent in India can claim the same priority date while filing in other member countries within 12 months. This helps Indian innovators expand protection globally without losing filing advantages. The convention laid the foundation for harmonized international protection of industrial property rights. Patent Cooperation Treaty, 1970. The Patent Cooperation Treaty, concluded in 1970 and administered by World Intellectual Property Organization, enables investors to file one international patent application valid across multiple member countries. It simplifies and delays the cost of seeking patent protection in different jurisdictions. The PCT system includes an international search report and preliminary examination, which assesses novelty and patentability before national filings. India became a PCT member in 1998, and the Indian Patent Office acts as both a receiving and searching authority under the treaty. For example, an Indian startup developing a new AI-based healthcare device can file a single PCT application through World Intellectual Property Organization to secure patent protection in up to 150 plus countries. This system promotes innovation, reduces administrative burdens, and helps Indian inventors expand globally with ease. NAFTA, North American Free Trade Agreement, 1994. The North American Free Trade Agreement is effective from 1994. It was signed between United States, Canada, and Mexico to form a free trade area. Although its primary aim is to remove trade barriers, it also introduced a detailed framework for intellectual property rights. NAFTA set high standards for the protection of patents, trademarks, copyrights, and trade secrets, influencing later global agreements like the World Trade Organization's TRIPS agreement in 1995. While India is not a member of NAFTA's model, significantly influenced India's IP reforms during post-TRIPS implementation. For example, India's Patent Amendment Act of 2005, which introduced product patents for pharmaceuticals, reflected the global harmonization trend seen in NAFTA. The agreement eventually evolved into the USMCA 2020 but remains a landmark in linking trade and IP protection. Impact of global IP agreements. Global IP agreements such as TRIPS 1995, Berne Convention, Paris Convention, and Patent Cooperation Treaty have transformed how countries protect and trade intellectual property. These treaties have harmonized IP standards, simplified cross-border protection, and encouraged innovation and foreign investment. For India, joining these efforts led to major reforms in IP laws, such as Patents Amendment Act 2005, which aligned with TRIPS by introducing product patents in pharmaceuticals. Similarly, India's participation in the Madrid Protocol of 2013 made global trademark registration easier. While these agreements promote innovation and technology transfer, they also raise challenges like higher drug prices due to strict patent laws. Overall, global IP treaties has strengthened India's IP regime, improved global competitiveness, and enhanced international cooperation in innovation and creativity. TRIPS agreement and harmonization of IP laws across countries. The trade-related aspects of Intellectual Property Rights Agreement, adopted in 1994 as part of the World Trade Organization framework, represents the most comprehensive and influential international treaty on intellectual property protection. It came into force on 1st January 1995, setting minimum standards for IP protection that all WTO member nations must follow. TRIPS integrates IP rights within the global trade system, ensuring that innovation and creativity are protected while facilitating fair competition and technology transfer. Objectives of trade-related aspects of intellectual property rights are establish uniform minimum standards of protection of patents, copyrights, trademarks, industrial designs, and geographical indications. Integrate IP protection into international trade, making it a subject of multilateral enforcement under the World Trade Organization. Prevent trade distortions caused by inconsistent national IP laws. Balance the interest of IP owners and users, ensuring access to essential goods like medicines and technology. Mechanisms of harmonization. Before trade-related rights agreement, intellectual property protection varied wildly across nations. Developed countries had strong IP systems, while developing ones, including India, had weaker regions. TRIPS harmonized these differences by defining global standards for duration, scope, and enforcement of IP rights. For example, patent must now be protected for 20 years from the filing date across all member countries, mandating enforcement procedures, including civil, administrative, and criminal remedies, creating a dispute resolution system under the WTO for IP-related conflicts between member states, encourage technology transfer and capacity building, especially for developing nations. Impact on India. India, as a founding member of World Trade Organization, became bound by the trade-related aspects of intellectual property rights agreement in 1995 and undertook a phased approach to comply. Key legislative reforms done by India are Patents Amendment Act 1999. It introduced a mailbox system for pharmaceutical and agrochemical patents. Patents Amendment Act 2002 brought patent term to 20 years, aligning with TRIPS standards. Patents Amendment Act 2005 reintroduced product patents in pharmaceuticals and chemicals, replacing the earlier process patent regime. Other changes included amendments of the Copyright Act 1999 and Trademark Act 1999 to align with TRIPS provisions. For instance, Novartis AG versus Union of India highlighted the balance TRIPS encourages between innovation and public health. The Indian Supreme Court rejected Novartis' patent for the cancer drug Gleevec under Section 3 of D of Patents Act, preventing evergreening of patents. This decision reinforced India's commitment to both TRIPS compliance and public welfare. Criticism and challenge: while TRIPS promotes uniformity, critics argue it benefits developed nations and multinational corporations more than developing economies. The enforcement of strict patent laws has increased medicine costs and limited local innovation in poorer countries. India, through Doha Declaration and compulsory licensing, continues to use strict flexibilities to ensure affordable access to medicines. The TRIPS agreement revolutionized global IP protection by harmonizing laws and creating a universal baseline for enforcement. For India, TRIPS was both a challenge and an opportunity. It compelled major reforms in IP law while preserving public interest safeguards. The balance between innovation, trade, and social welfare remains at the heart of TRIPS' global influence and India's IP policy framework. Evaluation of the Berne Convention and its role in copyright protection. The Berne Convention for the Protection of Literary and Artistic Works, adopted in 1886 in Berne, Switzerland, is a cornerstone of international copyright law. It was the first multilateral treaty to recognize the rights of authors and creators across national boundaries. The convention is administered by the World Intellectual Property Organization and now includes 180 plus member countries, including India. The Berne Convention embodies the principle that creative works deserve protection automatically without the need for formal registration. Historical evolution: The Berne Convention emerged from the need to protect authors whose works were being exploited in foreign countries without authorization or payment. Before 1886, copyright protection was largely territorial; authors' works were protected only in their home countries. Adoption: 1886, the original convention protected literary and artistic works such as books, plays, and paintings. Subsequent division: it has undergone several revisions to adapt to new media and technologies. 1971 Paris Act: this version remains the current and binding form. It introduced provisions balancing the interests of developing countries, allowing limited uses of copyrighted works for educational purposes. The core principles of Berne Convention is based on three fundamental principles. National treatment: each member country must provide the same level of copyright protection to foreign authors as it gives to its own nationals. Automatic protection: copyright arises automatically upon creation; no registration or deposit is required. Independence of protection: protection in one country is independent of whether the work is protected in the country of origin. It also introduced minimum standards for copyright duration, typically the author's lifetime plus 50 years, though many countries, including India, have extended it to 60 years. India and the Berne Convention. India became a member of Berne Convention in 1928 during the British colonial period and later reaffirmed its commitment as an independent nation. The Indian Copyright Act 1957 was enacted to align with Berne principles, ensuring that literary, artistic, musical, and dramatic works receive adequate protection. Subsequent amendments, especially in 1994, 1999, and 2012, further harmonized India's copyright laws with global standards. For example, Copyright Amendment Act 2012 introduced stronger rights for authors, composers, and film artists, reflecting Bernie's emphasis on moral and economic rights. A practical example is the protection of Bollywood films and Indian music abroad under Bernie, as the works of Indian creators enjoy automatic copyright protection in all member countries without separate registration. The Berne Convention plays a pivotal role in creating a global copyright framework by ensuring uniform protection across borders for authors and artists, encouragement of creativity and dissemination of knowledge, international cooperation in enforcement through WIPO, adaptability to modern technologies such as digital works, digital and online works. It also complements other IP treaties like WIPO Copyright Treaty 1996 and TRIPS Agreement 1995, both of which have reaffirmed Berne's core principles and extend protection to digital works and software. Challenges and contemporary relevance. While Berne has successfully harmonized copyright laws, challenges persist in the digital era, where piracy and unauthorized online distribution are widespread. In India, enforcement remains a concern despite a strong legal framework. This balance between protecting authors and promoting public access to knowledge, especially in education and research, continues to be debated. The Berne Convention has evolved from a 19th century treaty into the backbone of modern international copyright law. It laid the foundation for automatic and equal protection of creative works worldwide. For India, the convention not only shaped national legislation but also enhanced the global recognition of Indian literature, cinema, and art. It is increasingly digital and globally evolved. Berne's legacy continues to safeguard the rights of creators. Madrid Agreement and Madrid Protocol facilitating international trademark registration. The Madrid System is a primary international framework for Madrid system is the primary international framework for registering trademarks across multiple countries through a single application. It is administered by World Intellectual Property Organization and consists of two treaties, that is Madrid Agreement and Madrid Protocol. Together, they simplify the process of securing trademark protection internationally, reduce cost, and encourage cross-border commerce. India became a member of Madrid Protocol in 2013. Madrid Agreement. The Madrid Agreement was original treaty establishing an international framework for trademark protection. Its key features include single international application. Applicants could file one application with WIPO based on a home trademark registration in their country. Automatic protection in designated countries. The application could be extended to all member countries designated at the time of filing. Centralized management. WIPO serves as central registry simplifying renewals and modifications. However, the agreement had limitations. Only original registration could be the basis for international applications, and the system lacked flexibility for designating non-member countries. These limitations led to adoption of Madrid Protocol in 1999. The Madrid Protocol modernized the system, making it more flexible and widely accessible. Key improvements include applications based on pending domestic applications. Applications can file internationally even if their national trademark is not yet registered. Over 120 countries are now members, including India, the USA, and EU nations. Changes such as renewals, ownership transfers, or modifications can be done centrally through WIPO rather than filing separately in each country. Process for Indian applicants: file a basic application or registration in India at the Office of the Controller General of Patents, Designs and Trademarks. Submit an international application through the Indian Trademark Office to WIPO. Designate member countries where protection is sought. WIPO examines the formalities and forwards application to designated national office for substantive examination. For example, Tata Motors, when launching the Tata Nexon EV globally, could file a single Madrid Protocol application to protect its trademark in multiple markets like Europe, US, and Australia, avoiding separate national filings. What are the advantages? One application holds multiple countries, time efficient, centralized control, and global brand protections. While cost-effective, the system requires careful selection of designated countries to avoid refusals. National offices retain the right to refuse protection, which can affect international enforcement. Indian applicants must ensure the basic Indian registration remains valid for 5 years, as the international registration depends on it. The Madrid Agreement and Madrid Protocol have revolutionized international trademark protection by providing a single streamlined system for businesses worldwide. For India, joining the Madrid Protocol has enhanced the global competitiveness of Indian brands, making it easier for startup IT companies and large corporations to secure trademarks across multiple jurisdictions. It exemplifies how international cooperation through WIPO can reduce procedural barriers and foster global trade while maintaining respect for national laws. Patent law treaty and harmonization of patent filing procedure. The patent law treaty, concluded in 2000 and administered by the World Intellectual Property Organization, is a key international instrument aimed at simplifying Patent Law Treaty, concluded in 2000 and administered by World Intellectual Property Organization, is a key international instrument aimed at simplifying and harmonizing patent filing procedures across different jurisdictions. While it does not create substantive patent rights, the PLT focuses on formal requirements such as filing, renewal, and documentation to reduce complexity and cost for inventors, particularly those seeking patent protection in multiple countries. India is a member of WIPO and is progressively aligning its patent filing practices with international standards, making the PLT making the PLT relevant for Indian innovators seeking global patent protection. Objectives of the Patent Law Treaty: harmonization of formal procedure establishes uniform standards for submitting patent applications, including required documents, deadlines, and formats. Reduction of administrative burden simplifies processes to make patent systems more user-friendly and cost-efficient. Flexibility of applicants provides standard periods of time to correct deficiency or comply with procedural requirements. Promotion of international patent filing encourages investors to file in multiple jurisdictions without excessive procedural hurdles. Standardized filing requirements, including uniform rules for application forms, claims, drawings, and sequence listing, time limits and extensions. Applicants are given standardized timeframes to remedy deficiencies such as missing parts of the application. Communication and documentation. PLT permits electronic filing and communications with patent offices, promoting efficiency. Avoidance of technical barriers ensures that national procedural rules do not unnecessarily hinder international patent filings. Before the PLT, inventors had to navigate vastly different patent office procedures in each country, often leading to confusion, delays, and additional costs. The PLT addresses these issues by creating uniform procedural standards, thus reducing the risk of errors that could result in abandonment of application. For example, an Indian startup in the pharmaceutical industry can file in India and in PCT member states using PLT standards to ensure document deadlines and formats are accepted by other offices. India's Patent Rules 2003, as amended in 2016, have incorporated several PLT-inspired provisions. Time extensions, acceptance of electronic filings, and standard formats for claims and specification reduced procedural complexity for filing subsequent applications and priority claims. Indian innovators such as pharmaceutical like Cipla and IT firms like Infosys benefit from these harmonized procedures when filing patents abroad, particularly in PCT member countries. This fosters global competitiveness and facilitates technology transfer. Not all patents fully adopt PLT provisions, so discrepancies may still exist. Harmonization focuses on formalities, not substantive patentability, meaning inventors still need to meet each country's technical standards. The Patent Law Treaty plays a crucial role in reducing procedural barriers and harmonizing patent filing worldwide. For India, it has enhanced the efficiency, accessibility, and predictability of patent applications for domestic innovators seeking international protection. By simplifying formal requirements and enabling global alignment, the PLT complements other international instruments like the Patent Cooperation Treaty, supporting India's growing innovation ecosystem and contributing to global technology development. Objectives of the TRIPS agreement and balancing IP owners and public interest. The trade-related aspects of intellectual property rights. TRIPS agreement administered by the WTO came into effect on 1st January 1995. TRIPS is the most comprehensive intellectual property treaty integrating intellectual property rights within the global trade framework. Its objective is to harmonize IP standards, promote innovation, and ensure enforcement while balancing the rights of creators with public interest concerns such as access to knowledge, medicines, and technology. The main objectives of TRIPS are harmonization of IP standards. TRIPS establishes minimum global standards for patents, copyrights, trademarks, industrial designs, and geographical indications. All WTO members must comply, ensuring uniformity and reducing trade distortions. Protection of IP owners' rights. TRIPS safeguards inventors, authors, and businesses, granting exclusive economic and moral rights, preventing unauthorized use and fostering innovation. Integration of IP and trade. By linking IP protection with trade rules, TRIPS allows enforcement through WTO dispute settlement mechanisms, ensuring compliance and international cooperation. Promotion of technological development and transfer. TRIPS encourages the dissemination of technology, especially to developing countries, balancing the need for protection with global development goals. Balancing interests of IP owners and public. TRIPS recognizes that absolute protection of IP can conflict with public welfare, particularly in areas like healthcare, education, and food security. To address this, it provides flexibilities like compulsory licensing, allowing governments to authorize production of patented products without the consent of the patent holder under specific conditions. And in India, in 2012, the Indian firm NATCO was granted a compulsory license to manufacture Bayer's patented cancer drug sorafenib Nexavar, making it affordable for patients. Parallel importation. Countries can import a patented product sold at lower price upfront without infringing local patents. Exceptions for public health and education. TRIPS Article 30 allows limited exceptions to IP rights to address public needs, supporting access to medicine and educational materials. Transition periods for developing countries. Developing nations like India were given extra time to comply fully with TRIPS, allowing gradual adaptation of domestic laws. India undertook significant legislative reforms to comply with TRIPS. Patents Amendment Acts 1999, 2002, 2005 introduced product patents for pharmaceuticals and chemicals. Copyright Amendment Act 1999 strengthened protection for author software and digital work. Trademarks Act 1999 aligned Indian trademark law with international standards. These reforms encourage innovation, foreign investment, and technology transfer, while TRIPS flexibility ensured public interest safeguards, particularly in healthcare and education. The TRIPS agreement seeks to harmonize IP production globally while ensuring that public interests around are not compromised. Objectives of SAFTA and incorporation of intellectual property rights. The South Asian Free Trade Area (SAFTA). Objectives of SAFTA and incorporation of intellectual property rights. The South Asian Free Trade Area, signed in 2004 and implemented in 2006, is a regional trade agreement among eight South Asian nations, including India, Pakistan, Bangladesh, Sri Lanka, Nepal, Bhutan, Maldives, and Afghanistan. Its primary objective is to promote intra-regional trade and economic cooperation by reducing tariffs and trade barriers. Beyond conventional trade liberalization, SAFTA also recognizes the importance of intellectual property rights in enhancing competitiveness, innovation, and regional development. Main objectives of SAFTA: reduction of tariffs. SAFTA aims to reduce tariffs on goods traded among member countries. Main objectives of SAFTA: reduction of tariffs. SAFTA aims to reduce tariffs on goods traded among member countries to 0 to 5%. Promotion of regional trade and investment. Economic integration, support for economic development of least developed countries like Nepal, Bhutan, Afghanistan, Maldives. Incorporation of intellectual property rights. While SAFTA primarily focuses on tariffs and trade liberalization, it incorporates provisions related to IPRs to ensure that Regional trade benefits from legal protection of innovation and creative works. Harmonization of IP standards after encourages member states to align their domestic IP laws with international treaties such as WIPO treaties and Berne Paris conventions. This facilitates mutual recognition and protection of patents, trademarks, and copyrights. Protection of regional innovation by promoting IP rights. NAFTA promotes regional innovations such as Indian law in protecting their products. Encouragement of technology transfer and collaboration. Strong IP origins under NAFTA enhance trust among countries for joint research, R&D collaboration, and cross-border investment. Dispute resolution mechanism, though limited compared to WTO, NAFTA encourages amicable resolution of trade disputes, including IP-related dispute agreements. India is the largest economy in the region, benefits significantly from NAFTA. Main WPO treaties and their role in international IP cooperation. The World Intellectual Property Organization, a specialized agency under United Nations located in Geneva, Switzerland, is started in 1967 and it administers around 26 international treaties like Vienna Convention, Paris Convention, PCT, etc. These treaties serve as mechanisms for international protection, cooperation, harmonizing IP laws and procedure across countries to foster innovation, creativity, and economic growth. India has been an active member since 1975, participating in WPO's policy-making dispute. India has been an active member from 1975, participating in WPO's policy-making, dispute resolution, and training programs. Indian inventors, authors, and business benefit from WPO treaties to protect their intellectual creations globally. Berne Conventions for protection of literary and artistic works. Protect literary, artistic, musical, and cinematography works. Includes principles of automatic protection, national treatment, and moral rights. Indian Copyright Act 1957 aligns with Berne provisions ensuring automatic protections for works like Bollywood films and Indian literature. Paris Convention for protection of copyrights for industrial property. Berne Convention for protection of literary and artistic works. Paris Convention for the protection of industrial property. Covers patents, trademarks, industrial designs, and utility models. Introduces national treatment, right of priority, and independence of patents. Indian inventors can claim priority in multiple countries within 12 months of filing a domestic patent. Patent Cooperation Treaty simplifies international patent filing through a single application, provides international search on preliminary. Indian inventors can file PCT application through the Indian Patent Office. Indian Patent Office gaining protection in over 150 countries. Madrid Agreement and Madrid Protocol facilitate international trade mark registration via centralized system management. So, India joined the Madrid Protocol in 2013, enabling Indian companies to start handling global efficiently. Hague Agreement governs international registration of industrial designs. WPO Copyright Treaty, Performance and Programs Treaty. Lisbon Agreement, protection of geographical indications, important for products like Darjeeling tea and basmati rice. Harmonization of IP laws, centralized filing system, capacity building, dispute resolution, promotion of innovation. UNESCO and intellectual property rights in cultural heritage and creativity. United Nations Educational and Scientific and Cultural Organization established in 1945. Promotes peace, education, science and culture globally. UNESCO is not a traditional IP enforcement agency like WPIPO. It plays a crucial role in linking intellectual property rights with the protection of cultural heritage and in linking intellectual property rights with the protection of cultural heritage and creativity. Its initiative emphasizes safeguarding tangible and intangible cultural assets, traditional knowledge, folklore, and creative expressions while supporting economic and social development. India, with its rich cultural heritage and vibrant creative industries, engages with UNESCO programs to preserve and promote its heritage while aligning with global IP norms. UNESCO's role in cultural heritage protection. UNESCO protects cultural heritage through several key conventions and programs. World Heritage Convention safeguards tangible heritage like monuments. Convention for safeguarding intangible cultural heritage. Oral traditions, performance art, rituals, and craftsmanship. Rights over traditional knowledge and cultural expression. Convention on the Protection and Promotion of the Diversity of Cultural Expressions. Protection of traditional knowledge and folklore. Promotion of creativity and cultural industries. Capacity building and awareness. International cooperation. UNESCO and IPR share a complementary relationship. UNESCO safeguards cultural heritage and creativity, and IP laws protect and commercialize these assets, ensuring economic, social, and cultural benefits. For India, this synergy is vital in preserving the rich legacy of tangible and intangible heritage while fostering innovation, entrepreneurship, and global recognition of cultural assets. ARIPO, African Regional Intellectual Property Organization, established to facilitate the protection and development of intellectual property rights in Africa. Created under Harare Protocol in 1976, headquartered in Zimbabwe, primarily serves English-speaking African countries, while WPO is global specialized agency. Haribo focuses on regional IP administration. Main purpose is regional IP cooperation, simplified registration system, capacity building and technical assistance, promotion of innovation and technology transfer. Harare Protocol on Patent and Industrial Designs, Wanzel Protocol on Marks, Harsha Protocol on Protection of Traditional Knowledge and Expressions. In Indian context, India is not a member of IPO. Key principles of Paris Convention and its influence on modern industrial property law. The Paris Convention for the Protection of Industrial Property, adopted in 1883, is one of the oldest and most influential international treaties in the field of intellectual properties. It addresses the protection of patents, trademarks, industrial designs, utility models, and unfair competition. The Convention applies the principle of national treatment, ensuring that foreign inventors and visitors receive the same protection as domestic applicants. India became a member in 1998, aligning its industrial property laws with the Convention provisions to encourage innovation and facilitate international trade. Key principles of Paris Convention. National treatment. Member countries must treat foreign applicants the same as their nationals regarding the protection of industrial property rights. Right of priority. Applicants can find priority for their parents' trademark and designs filed in one member country and filing in other within 12 months for patents and 6 months for design and trademark. This principle allows inventors to secure international protection while maintaining original filing date. Independent of patents. Patents in different countries are independent. Rejection or invalidation in one country does not affect others. Protection against unfair competition. Common rules for industrial property. Influence on modern industrial property law. Patent law, trademark law, industrial defense and civil international cooperation.